Okay, so welcome everybody. Thank you for being here. Bienvenidos todos. Gracias por estar acá. Les pido por favor que al salir o al entrar se anoten después en las listas que están afuera. Una formalidad para poder justificar el café que viene al final del evento. So thank you for coming. We are pleased to have you, and we are pleased to have this amazing panel. And we are pleased to welcome Sofia Moreau from New York University. She's professor of law and philosophy there. She works in anti-discrimination law and tort theory, and she also has a large philosophical scholarship. She is originally coming from Canada. She taught there at Toronto University, and she's been visiting fellow in many places. I'm not gonna read her whole resume because it will take forever. But I do want to mention one of her main publications that I think are very valuable for many of us here, which is her book, Faces of Inequality. So she's going to give us the main talk today, and then we'll have comments from the rest of the panel here, which I will also introduce perhaps more briefly. So first, I'm going to introduce Lieta Vivaldi. She's a lawyer from this law school, but she's also PhD in sociology from Goldsmith. I'm translating while I'm reading, so it may take a while. She's now a professor at Universidad Alberto Hurtado, but she's also a professor in the University of Chile in the philosophy department. She's member of the Association of Feminist Lawyers, and she specializes in human rights, sexual and reproductive rights, critical sociology, biopolitics, ethics, and feminism. Then we have Gustavo Beade, who's a doctor in law or PhD in law from the University of Buenos Aires, La UBA. He has a master in law from University Palermo, and his undergrad is from UBA as well, Buenos Aires. He's now professor of law at Universidad Austral de Chile in Valdivia, and he specializes in philosophy of criminal law, legal, moral and political philosophy, and criminal law. Then we have Alberto Kudu, who's also from our law school. He studied law here. His doctorate is from University College of London, and he did an LLM at New York University, where Sofia is a professor now. He used to be a professor at Universidad Austral, but now he's a professor at the Catholic University, but not at the law school, but at the School of Government. And she works on new technologies and law, fundamental rights, and the challenges for public law and labor law of the new technologies. And last but not least, we have Pablo Marshall, who's also a lawyer from this law school, a doctor in law from University of Glasgow, and a professor at Universidad Austral. He's also director of the Núcleo Milenio of Disability Studies, DISCA, also a researcher in the Institute Milenio Micare, and he has specialized in constitutional law, political rights, and disadvantaged groups' rights, and disabled rights, or I don't know. Disability law. Okay. Well, at the 50s me, but I'm not going to introduce myself. Okay, so we're going to do it this way. We're going to start by listening to Sofia's talk. And after that, we are going to do a round of questions here, all of the commentators in the panel. Then Sofia will have some time to reply, and then we will open to you to make your comments, questions, observations, and then she'll have one or maybe more than one opportunity to engage with those questions. So that said, thank you so much, Sofia, for visiting us here. It's really an honor, and the microphone is yours.
Thank you so much, Rocio. Thank you to all of you, and many, many thanks to my commentators. I'm really honored to be here and honored that you would take so much time and thought to engage with my work, and I look forward to our conversations. So it's a commonplace that individual discriminatory acts and practices most often occur within a context of systemic and structural discrimination against the same groups. When a European hospital denies Roma women obstetrical care or separates them from other patients and crowds them into a single gypsy room, this doesn't reflect an idiosyncratic bias on the part of these doctors or these hospital administrators. It taps into and in turn reinforces broad cultural stereotypes. Both stereotypes about Roman peoples as dirty and contagious, and stereotypes about Roma women as untrustworthy and uncontrollable. These stereotypes have been institutionalized, that is to say, built into the structure of particular social institutions as the avowed justification for particular policies. And of course, the different institutional policies across different social contexts intersect to reinforce and compound the disadvantages faced by Roma women. These women encounter discrimination not only in healthcare, but in education, in employment. They face increased police brutality, and they often live in poverty. So we recognize that discrimination is often systemic, but both within domestic law and within international human rights law, I think we lack a principled understanding of how courts and tribunals should approach discrimination if they wish to understand it as systemic. We also lack an understanding of what systemic remedies might look like and of how seeing discrimination as systemic might help us identify injustices or aspects of injustices that might otherwise be invisible. This picture that you see on this PowerPoint now is a collage that was put together by our inquiry on missing and murdered Indigenous women in Canada, which I'll talk more about later. But in a sense, it represents the problem with how we often see discrimination now. We see it often just as an aggregation of individual acts of discrimination. The gaps in our understanding of systemic discrimination, I think, are partly explained by the fact that the institutional mechanisms for identifying and rectifying discrimination in most countries rely on particular claimants to come forward and challenge particular policies, one at a time. Most countries' domestic anti-discrimination laws target individual acts of discrimination and look for individual perpetrators, even in cases of group-based disparate impact. And although, of course, there's often room for claimants to bring evidence pertaining to broader discriminatory practices and underlying structural injustices, the ultimate goal is not usually to address the problems in a systemic way. It's usually just to figure out whether this perpetrator needs to change this policy. So although there is, of course, a rich literature on structural injustice within political theory, and rich literatures on structural racism and structural obstacles to women's equality, both our legal mechanisms and our legal literature on discrimination focus predominantly on individual acts of discrimination and individual policies. However, within international law, there are certain institutions that are capable of taking a broader society-wide view of discrimination and that are even charged with the task of identifying and suggesting remedies for systemic discrimination. One of these is the UN's Committee for the Elimination of Discrimination Against Women, the CEDAW Committee. It's the body of independent experts that monitors the implementation of the UN's CEDAW Convention. Now, the CEDAW Committee can initiate inquiry procedures into member states whenever it has reason to believe there are grave or systemic violations of the rights in the conventions, or I should have said systematic, grave or systematic violations. Because the convention imposes on member states in Article 2E an obligation to take, quote, all appropriate measures to eliminate discrimination against women by any person, organization, or enterprise within its jurisdiction, The committee is not limited to looking at isolated policies, the way most domestic anti-discrimination laws do, or even to looking only at government policies. Rather, the committee can take a bird's eye view on society as a whole, looking at discrimination both by the state and by private actors, and at least in principle, it's able to examine the interaction of different policies across different contexts. Now, unfortunately, quite often in practice, it doesn't. Although the committee does survey the state of discrimination within a given jurisdiction, it often proceeds article by article through the treaty rights, looking at discrimination first in one context like healthcare and then in another like education or transportation, without fully ever exploring how different policies across different contexts compound disadvantage and reinforce past discrimination. Nevertheless, the CEDAW committee has the institutional resources, at least, to analyze systemic discrimination. What it needs is partly a proper conceptual framework for thinking about systemic discrimination and a more precise account of what the point of an inquiry into systemic discrimination should be. It also, of course, needs more funding, which would help it take the time that is needed to do these sorts of investigations. In this short talk, I'm not going to lay out a whole framework for thinking about systemic discrimination, but I want to push us a little beyond what the CEDAW committee has suggested systemic discrimination involves, and I want to do so using the committee's own observations about particular cases, as well as the recent ruling of the UN Permanent People's Tribunal for the Women of Afghanistan. I also want to say something about the different insights we can gain when we see discrimination as systemic. Now, the CEDAW committee doesn't refer explicitly to systemic discrimination. The term they use is systemic violations of equality rights. But they've repeatedly interpreted systematic violations as meaning something very close to systemic discrimination. They have defined systematic violations as a significant and persistent pattern of violations, that is, violations of the rights to non-discrimination in the treaty, which are not a random occurrence. They've also noted that the systematic denial of equal rights for women can take place either deliberately, namely with the state party's intent of committing these acts, or as a result of discriminatory laws or policies or acts with or without such a purpose. So understood, systemic discrimination involves patterns of discrimination consisting of both intentional and unintentional forms of discrimination. The unintentional ones perhaps involving policies that have an adverse impact on a group marked out by a prohibited ground of discrimination, or a disproportionately disadvantageous impact on that group relative to others. Most often, of course, systemic discrimination involves both intentional forms of discrimination and unintentional forms. That is to say, both direct discrimination or disparate treatment, in which a practice treats someone less favorably on the basis of some trait than it treats or would treat those who lack that trait, and indirect discrimination or disparate impact, in which a facially neutral practice, one that doesn't look like it draws any explicit distinctions, either disproportionately disadvantages those who have a certain trait relative to those who don't, or perhaps just imposes a further disadvantage on a group that's already marginalized or disadvantaged. Both of these are standardly treated by the law as wrongful when the trait in question ought to be a prohibited ground of discrimination and when there are no relevant justifying factors. Now, the idea that systemic discrimination involves patterns of repeated instances of direct and indirect discrimination is a helpful start, but in none of its inquiry reports does the CEDAW committee explain exactly what kinds of patterns mark out systematic violations or systemic discrimination. We might ask, patterns in what? You might think, patterns in the groups that are excluded or that face discrimination, patterns in the ways that they're excluded or disadvantaged, and patterns in the wrongs thereby suffered. And I don't know if any of you know the Red Dress Project, but the photo that I have on the bottom there is from a part of a project. It's an art installation, but it's become a wider form of political activism, certainly in countries like Canada. The red dresses symbolize all of the missing and murdered Indigenous women, and indeed all Indigenous women who have become faceless and voiceless and anonymized and uncared for in this morass of disadvantage and marginalization that they face. Now, I've defended a particular account of how discrimination wrongs people in my book, Faces of Inequality. I gather that all of you have read it, and probably more recently than I read it, so probably you know it even better than I do, but I will just briefly say a few things about it. I've argued there that both direct and indirect discrimination can wrong people for a number of reasons concurrently or also separately, so I have a pluralist account of when discrimination is wrong. Sometimes it wrongs people by marking them out as a subordinate social class, placing them beneath others. Sometimes it wrongs people by denying them what I've called a deliberative freedom, the freedom to make certain choices about how to live your life without always having certain traits or their costs or other people's assumptions about them before your eyes, always as an extra factor in your decision making. And sometimes discrimination wrongs people because it leaves them without access to a basic good, a good necessary for them to function as equals in their society. I'm mentioning this to you now only as an illustration. Nothing that I'm going to go on to say about systemic discrimination depends on this particular account of what makes individual acts and policies wrongful as discrimination. Now, if we think, as the CDAW committee suggests, that systemic discrimination is a pattern comprised of wrongful acts of direct and indirect discrimination, this might just give the impression that systemic or systematic just means many similar instances, like that montage that I showed at the start of the presentation of the individual faces of individual women. And if systemic discrimination is just a large number of discrete incidents that resemble each other, of individually identifiable and individually understandable cases of direct or indirect discrimination, each of which is wrong taken by itself, then it's unclear really what the benefits would be of trying to understand discrimination as systemic. All we would need to do to understand systemic discrimination is aggregate our analysis of the wrongs done in individual cases to form a picture like that picture of the individual faces. But of course, this is too simple. As we know from the rich literature on structural injustice, and for instance, in structural racism, systemic discrimination doesn't only involve a large number of similar individual acts of discrimination. It also involves institutionalized forms of exclusion and disadvantage, both through social institutions and through legal ones. Interconnections between these different institutional exclusions and disadvantages, whereby they reinforce and compound each other's impact and together strengthen the stereotypes that often rationalize them. Pervasiveness across many different contexts like education, healthcare, employment, law enforcement, transportation, and often a qualitatively different impact on the relevant social groups, a kind of additional wrong. I'll talk more about this later, whereby these groups are in some ways segregated or denied full status as citizens, or perhaps even denied full status as persons in their society. And additionally, systemic discrimination is often self-perpetuating, in the sense that even after individual unjust laws and policies are repealed, the exclusions and the disadvantages tend to persist. Now, when we conceptualize systemic discrimination as involving these additional features, I think it becomes apparent that seeing discrimination as systemic is often crucial for several reasons. First, even where individual acts of discrimination are cognizable as discrimination and as individual wrongs, seeing them within the broader context of systemic discrimination is often necessary if we're to understand their cumulative impact on certain groups, and if we're to see them as wronging these groups in certain additional ways. Second, seeing discrimination as systemic can be necessary to make visible acts of discrimination that might otherwise be invisible. Many instances of indirect discrimination or adverse impact discrimination may not appear discriminatory at all when considered individually. They might just look like neutral policies adopted on reasonable grounds. It's only when we scrutinize their full impact on groups marked out by a prohibited ground of discrimination and understand the generalizations that rationalize them as questionable, possibly false or under-inclusive or over-inclusive stereotypes that are applied to these groups repeatedly across different contexts that we may be led to see them as discriminatory. And third, it's only by seeing discrimination as systemic that we're led to focus not just on individual acts and policies and their effects, but on the reinforcement mechanisms through which discrimination becomes pervasive and self-perpetuating, persisting even when we attempt to change our laws. And lastly, focusing on the reinforcement mechanisms is necessary if we're to target and eliminate some of the causes of discrimination, the causes of the kind of discrimination that just persists, even through large-scale attempts to change our formal policies. Now, in the rest of my talk, I want to draw out these 4 consequences of seeing discrimination as systemic, with the help of several case scenarios considered by the CEDAW Committee and by the Permanent People's Tribunal for the Women of Afghanistan. So, firstly, even where discrimination is visible, seeing it as systemic often reveals a qualitatively different impact on the group and additional wrongs. Consider the case of gender-based discrimination in Afghanistan today. That painting that you see in the bottom right corner of the slide is a painting by an Afghani woman artist, Nabila Horach, who's given me permission to use that. She does these amazing paintings that are intended to represent the horrors experienced by women in Afghanistan. She's now living herself in exile in Germany. In August 2021, the Taliban regained de facto authority within the country after nearly 2 decades, and they commenced what the indictment of the UN Permanent People's Tribunal has called a, quote, deliberate, systematic, and institutionalized campaign of repression targeting women, girls, and other marginalized groups. Just as an aside, I should mention, the UN Permanent People's Tribunal is a special mechanism. It was set up by the UN in 1979 as an independent forum for cases of grave violations in human rights where formal legal systems have failed people. So it was convened in October of last year, and its prosecutors charged the de facto authorities within the Taliban with crimes against humanity, including the crime of gender persecution and violations of international anti-discrimination laws like CEDAW. Their judgment was released in December, convicting the authorities of all charges. Obviously, this is a court with symbolic and jurisprudential import rather than with the ability to actually punish those who are convicted. I was involved loosely as a consultant, and I found it really inspiring. The start of the indictment notes that, quote, the authority of the tribunal is grounded in the conscience of humanity, unquote. And I have to say, in an age when even my own Canadian Prime Minister tells us that the New World Order is just based on power, and I found it inspiring that somebody still believes in something called the conscience of humanity. And actually, it led me to reflect, but this is not the topic of today's lecture. Maybe we can talk about it later, that really, ultimately, that has to be what we see as the source of all law, or we end up where the country that I now live in has gone today. So the indictment and the judgment of the Permanent People's Tribunal in this case are both deeply important for the study of systemic discrimination. and they've been designed to be that way. So it's not on, the point is it was not only a way to give a voice to the women of Afghanistan, it's also intended as a useful tool for litigants in international law, because the idea is that the analyses of systemic discrimination that they have given in the judgment now have the imprimatur of the UN on them. So the judgment illustrates that even when we can already identify an act on its face as an act of direct intentional discrimination, we can't understand its full impact or the wrong that's done either to individuals or to the group marked out by the relevant ground of discrimination, unless we see it within the broader institutional context of systemic discrimination. In the case of Afghanistan today, we see the most extreme example of a deliberate, coordinated campaign against a certain group designed to turn them into second-class citizens and push them out of certain spheres of social life entirely. Through more than 126 gender-specific edicts and decrees, the Taliban has systematically banned girls from secondary and higher education, prohibited women from paid employment, prevented women from accessing health care, and restricted their movement without a male escort. It has also criminalized women's very presence in public places by making it a crime for a woman's voice to be heard in public. Although any one of these measures could on its own be identified as intentional discrimination targeting women, it's only when they're considered all together that we can see them as coordinated parts of a policy for institutionalizing male dominance and denying women equal status. This is underscored by the fact that the policies are enforced by a female-only morality police, and that across the board, women receive punishments for their transgressions that are disproportionately large relative to those received by men, and as we know recently, even to those received by people in the case of animal abuse. The latest Taliban edict makes the penalty for abuse of your animals greater than the penalty for domestic violence. In order to see how these policies turn women into a subordinate social class and separate them off from the rest of society, we clearly need to look at the intersection of many policies and take a kind of bird's eye view, the kind that systemic discrimination offers us. A constraining dress code for women in public places might not on its own place women in a subordinate class to men, but when it combines with restrictions on their voices in public places, restrictions on movement and employment, it functions not just to deny them a set of opportunities or freedom, but also to deny them an equal social status. Moreover, here, the combined effects of these many forms of gender-based persecution and gendered punishments is not just to mark out women as a subordinate class of beings, it's to render them invisible in certain areas of social life, in particular in public places, in political life, in the visible economy. They cannot exist within these spaces. They're effectively erased. In fact, the only sphere in which they are allowed to exist is the home. We can't understand this particular wrong, I think, unless we take a systemic view of discrimination. Okay, second, seeing discrimination as systemic is crucial because it can make visible otherwise invisible acts of discrimination. Now, the example I just gave a minute ago under small Roman numeral 1 of the Taliban's gender-based edicts, these acts were all explicitly discriminatory. But of course, in most jurisdictions, systemic discrimination involves a complex mixture of intentional discrimination on the one hand, and many forms of indirect discrimination on the other, many policies that look neutral, but end up further disadvantaging an already marginalized social group. In these cases, taking a systemic approach and exploring the ways in which certain forms of exclusion and disadvantage and related stereotypes have been institutionalized across different contexts is often necessary if we're to see certain policies as discriminatory in the first place. So as my example of this way of thinking of systemic discrimination as particularly crucial, I want to talk with you a little bit about the case of SMF versus Spain, in which the CEDAW committee found that Spain had violated its treaty obligations by not taking seriously the complaints of a woman about discrimination in the context of her pregnancy and delivery. This woman had arrived at the hospital and had a relatively unproblematic pregnancy, but was nevertheless subjected to a series of unnecessary and invasive interventions without adequate information and without her consent, resulting in lasting physical and mental trauma. When she brought her complaint to the hospital, they believed the doctor's claim that, quote, meaningful consent was not possible in the middle of labor, unquote. And when she brought her complaint about the doctor and the hospital to the courts, they deferred to the hospital. The CEDAW committee, in its decision, highlighted that all of these institutional responses, though they weren't coordinated, so they were totally unlike the Taliban's coordinated attempts. These were not coordinated, they weren't even deliberate attempts to subordinate women, but they relied on and further entrenched discriminatory assumptions about women. The doctor, the hospital, and the courts, each in turn, had relied on practices and assumptions that institutionalized the stereotype of women as occupying a passive, subordinate role in childbirth and as irrational during labor and incapable of processing information. So although each of these decisions on its own might appear to be reasonable, or if not reasonable, then just the result of one individual's misjudgment, nevertheless, when seen in the broader context of the medical profession and the judicial profession and their history of mistrusting women and denying women autonomy and agency, these practices can be understood as wrongfully discriminatory. They disadvantaged members of an already marginalized social group on the basis of false and stigmatizing stereotypes. So in this case, it was only by seeing these responses to this woman as part of a pattern of systemic discrimination through the interaction of medical hierarchies, gendered expectations of women's passive compliance during childbirth, and then judicial deference to medical authority, that the committee was able to see them as instances of discrimination in the first place. Okay, third, seeing discrimination as systemic is crucial because it focuses us on the underlying reinforcement mechanisms, the mechanisms through which discrimination becomes pervasive and self-perpetuating. Now, elsewhere in a paper that's forthcoming in a journal called Nomos, I've given a much more comprehensive analysis of what I'm here calling the reinforcement mechanisms through which systemic discrimination is perpetuated. But I want, in the remaining time that I have today, briefly to highlight some of these. And this is not by any means supposed to be a complete list. These are just some. One of the things I would love for during our discussion later is if you have thoughts about other such mechanisms, it would be wonderful to hear them. This is very much a project in progress. These reinforcement mechanisms include recurring stereotypes embedded in many institutions across different contexts, whereby policies in one context support the use of the stereotype in another, stigma that bleeds from one context to another, laws and policies that do what I'm calling individualize the discrimination. That is, they present it as the fault of either isolated discriminators, bad apples, we sometimes call them, or the fault of the victims themselves, thereby obscuring the systemic nature of the problem. And lastly, failing to see institutional inaction as a cause and looking instead only to acts and policies. In a sense, all of domestic anti-discrimination law does this in countries like the US and my own country, Canada, and that's one of the problems with it. So all of these reinforcement mechanisms that you see on the slide before you are visible in a scenario in Canada that has been taken up both by the CEDAW committee and by Canada's own governmental report on missing and murdered Indigenous women and girls. In Canada, Indigenous women and girls face discrimination across every social sector, and as part of this, they're much more likely than other women and men to be the victims of murder, abduction, and human trafficking. Although for years the Canadian government did what I have called individualize the problem, blaming Indigenous women for their poverty and their vulnerability on the grounds of persistent stereotypes, such as their laziness or their alleged propensity to choose dangerous lifestyles, like the lifestyle of a drug dealer or a prostitute, we slowly began to see the problem as a problem of widespread institutionalized discrimination and disadvantage stemming from the earliest days of colonization and continuing through the present day. One of my colleagues, Catherine Liu at McGill, has done wonderful work on ways in which colonization institutionalizes a whole variety of forms of discrimination, and that in societies with ongoing patterns of colonization, that's a crucial part of thinking about discrimination as systemic. The CEDAW Committee's inquiry report and Canada's own inquiry report have now highlighted the systemic nature of the discrimination that Indigenous women and girls face. In particular, they've revealed the many ways in which the very same public institutions that are now supposed to protect and assist Indigenous women have actually disempowered them over the course of our colonial history. At first, this happened deliberately and coercively, and now it happens through inaction and failures to provide adequate resources. So there's a really interesting pattern here of initial acts of deliberate, intentional, prejudicial discrimination and subjugation, followed by a repeal of offensive policies, but the persistent disadvantage and entrenched stereotypes continue. And then as a result, the same forms of exclusion and stigma are still felt, even though all of the relevant discriminatory laws have been repealed. So as some examples, our federal government was originally responsible for the forced relocation of Indigenous peoples in Canada. Of course, the reserves were all in uninhabitable areas where nothing could grow. They're now doing little to improve conditions on the reserves. The healthcare system coercively sterilized Indigenous women for years, treating them as though they were a kind of contagion. It no longer has official sterilization policies, but women still end up being coercively sterilized, and Indigenous women at vastly disproportionate rates to others. The child welfare system historically has regarded Indigenous women as immoral and unable to parent in civilized ways. We no longer have official policies to this effect, but local child welfare programs on reserves are so inadequately funded that a disproportionate number of children are still removed from their communities and placed miles away. So like with bitter irony, this ends up affecting the same sort of forced displacement of Indigenous children that Canada's brutal government-sponsored residential school system once deliberately aimed at. And perhaps the greatest irony of all was that the police, whose job it was in the early years of colonization to regulate the movements of Indigenous women and to enforce laws that portrayed Indigenous women as a threat to public security and public health and public morals, this same body is now in charge of investigating missing and murdered Indigenous women. The police in Canada in the early years actually used to run wife-beating classes for Indigenous men to teach them how to beat their wives. And they are now in charge of trying to investigate violence against Indigenous women. There is a systemic problem of the police delaying or dispensing with such investigations and telling families of these women that they should probably just wait a few days, they'll turn up, they're just choosing to go off and do drugs or engage in prostitution. Really, they don't need rescuing. So you can see even from this brief description, the recurring stereotypes underlying facially neutral policies, such as the stereotype of the Indigenous woman as immoral and unable to raise children responsibly, or as a criminal who's to blame for her own fate and doesn't need or deserve rescuing when she's abducted. I would urge you all, if you're interested in these sorts of questions, to look at the report because it's fascinating and it's over 1,000 pages. It traces these sorts of what I've described as rather generic stereotypes of Indigenous women as immoral to quite specific stereotypes from the earliest days of colonization, the stereotype of the Indigenous woman as squaw or the stereotype of the Indigenous woman as the vulnerable princess who wants to be conquered and can't govern herself properly. And then they show specifically how these stereotypes continue to run through a whole variety of institutions in Canadian society. You can also see the stigma, the negative valence associated with these stereotypes, which works invisibly and insidiously, I think, to lend credence to the idea that the heightened risks faced by Indigenous women, their heightened risk of violence, are all their own fault, and therefore that authorities have no obligation to take action to reduce these risks. You can also see the individualizing of the problem, blaming the Indigenous women through these stereotypes, or just sometimes blaming a few bad apples in the police force. Oh, well, it was just a particular lazy policeman who didn't investigate the disappearance of this one woman, or a particular child welfare worker who failed to think properly about Indigenous styles of parenting. And of course, there's been a system-wide failure to see the inaction of government bodies in healthcare, in child welfare, in education, in policing as partly responsible for the situation. Maybe we can talk more about that later, but the tort theorists, Martha Chamalis and Jennifer Riggins, have a really interesting chapter in one of their books on tort theory in which they talk about domestic violence and negligence. And they talk about omissions, and they note a whole set of psychological biases at work here. And one of them is the bias against omissions. We're just apparently, as a species, much less likely to treat omissions as causes than we are likely to treat explicit acts and policies as causes. But of course, in a context like this of colonialism and systemic discrimination, where there were these initial oppressive policies and the policies have changed, but the disadvantage and marginalization continues, the omission, I want to say, is culpable and does actually play a causal role in sustaining continued forms of discrimination. So it's because of these sorts of reinforcement mechanisms that systemic discrimination is so resistant to attempts to eliminate discrimination, just by eliminating individual discriminatory acts or even trying to reform the law so that it's just and so that it formally gives, for instance, Indigenous women all the legal rights to which they're entitled. With such persistent social stereotypes and stigma, and so many practices that continue to individualize the problem or overlook the causal role of omissions, it's never enough just to give the groups that have faced systemic discrimination a formal recognition of their legal rights. We really need to target and eliminate some of the reinforcement mechanisms that make it the case that systemic discrimination is so persistent and self-perpetuating. And this brings us to the final reason that I want to list for thinking that it's important to think of and see discrimination as systemic. And that is that hopefully, if we target the reinforcement mechanisms, we may be able to reduce discrimination, even in those cases where changes to our formal laws and policies are not enough. Now, this brings us to what I think is the most important question in this area, certainly from the standpoint of practice. What really would systemic remedies for discrimination look like? What forward-looking measures might actually work to address it? So this is where if my talk wasn't already inadequate, it becomes totally inadequate at this point, and I look forward very much to your helpful guidance. I don't think the CDAW committee has a good idea of what systemic remedies might look like. I'm not sure I do, but at the very least, I have a few suggestions. So I think they would need to involve measures designed, firstly, to name and counteract the specific reinforcement mechanisms that I've identified. Recurring false and stigmatizing stereotypes about the groups that face systemic discrimination need to be identified and called out as culturally grounded, or in the case of Indigenous women, the results of colonialism, so that both public officials and members of the public can see them as superimposed on these groups rather than as natural and unquestionable, and so that we can explore how they may work to sustain unfair disadvantages. Now, this paper is part of a broader project that I'm undertaking with my colleague Rebecca Cook at the University of Toronto Faculty of Law. She's done pioneering work in reproductive health law, and this strategy of naming and then critiquing stereotypes about women has worked very well as a matter of practice in women's reproductive health law within international law. The CDAW committee has also, in a number of decisions, actually required as one of the remedies that public officials learn about relevant, false, and stigmatizing stereotypes and about how they lead to wrongful discrimination. Now, such stereotypes, I take it, are part of what enables the stigma or the negative valence associated with certain groups to bleed from one context to another. So naming and calling out these stereotypes, I think, would also have the effect of helping a little bit to redress the stigma suffered by these groups, and to ensure that it doesn't continue to bleed from one context to another. Now, the third reinforcement mechanism that I discussed involved laws and policies that individualize the discrimination. Unlike stigma and false and misleading stereotypes, which are at least in principle erasable and substitutable, a lot of the laws and policies that individualize discrimination are a central part of our legal systems, right? Criminal laws that make the murder of any innocent person a crime, but which can also imply that the problem of violence against Indigenous women is just the problem of a few men who need to be behind bars. Or anti-discrimination laws that give every individual the right to bring a claim against organizations in certain contexts that discriminate against them, but which also suggest that all we need to do is tell Indigenous women to bring a few claims of discrimination against individual perpetrators, and then we'll have taken care of the problem. The problem with such laws, and the reason they function to individualize the problem of systemic discrimination, is not that they exist, I think, or that they're flawed as such. It's that governments assume they can work on their own to combat discrimination. So we need a series of measures designed to probe and address the many invisible ways in which different policies across different contexts combine to disadvantage and marginalize certain social groups. We need to explore, for instance, how healthcare policies and child welfare policies together leave Indigenous women especially vulnerable. How poverty on reserves, together with transportation policies that allocates most money to transportation within cities and leaves rural women on reserves with virtually no public transportation and hence no way of escaping abusive relationships, can leave them especially vulnerable. The final reinforcement mechanism that I mentioned involves the failure to see institutional inaction, and particularly government inaction, as among the abiding and pervasive causes of discrimination. Many countries' domestic anti-discrimination laws involve such failures insofar as they invite claimants only to challenge particular policies and have no mechanism for enabling claimants to challenge either the absence of a policy or a set of omissions working together. CDAW does, however, recognize positive rights and empowers individuals to question the failure of states parties to act. Article 2 states that states parties must fulfill, quote, all aspects of their legal obligations under the convention to, quote, respect, protect, and fulfill women's right to non-discrimination and to the full enjoyment of equality. In one of its general recommendations, the CDAW committee has insisted that while the obligation to respect is focused on negative rights, the right to be free from laws and policies that directly discriminate against women, the obligations to protect and fulfill, the CDAW committee says, provide positive rights against the state. That is, rights to ensure that governments actively intervene to eliminate discrimination and to rectify disadvantage. It's, of course, a very complex task to strategize about which measures would best fulfill such positive obligations. But we could start with a willingness to rectify certain basic omissions. We could focus, in the case of Indigenous women in Canada, on the absence of any governmental attempt to monitor hospitals to ensure that coercive sterilization has actually ended, on the absence of training for social workers in traditional Indigenous practices of child rearing and living, on the absence of educational training for police and of requirements that police follow up on reports of missing Indigenous women. The fact that a full set of positive measures to address systemic discrimination would likely require vast institutional and financial resources and a political will beyond what we currently have in most states doesn't mean that there aren't certain crucial omissions that it would be helpful to replace with meaningful action. There are still many things that can be done. Beyond these measures, though, it's a daunting task to think through what else might be feasible as remedial measures to address systemic discrimination. I don't have the answers now, but I will be working on this with Professor Rebecca Cook, and we'd very much welcome your thoughts. Thanks.
Thank you very much, Sophia, for that wonderful talk. And so, without further ado, let's just go to the comments. I'm revising the rule. Maybe I'll give Sophia a chance to answer after the first few, and then we'll go. So we'll go in this order. Okay. So we'll start with Alberto.
Well, thanks, Rocio, and thanks, Professor Moreau, for a wonderful work. So I've been following your work since 2010, probably when that "What is Discrimination" paper. So I think in my PhD thesis, I labeled you as or placing the wrongness of discrimination as not inequality at the beginning. So, but yeah, with the years, I've been it has been wonderful to follow the evolution of your work. So it's wonderful to be now talking on a different approach. So I think Professor Moreau's framework offers a sophisticated analytical lens for identifying and tackling systemic discrimination. However, I think the paper's engagement with the institutional consequences of legal concepts could definitely orient the reader towards a better understanding. And maybe I'm asking too much of the paper, but I think for legal audiences, what I'm going to say could help. I mean, as Neil Commissar would say, every legal concept entails institutional consequences. Even the silences, the emphasis, or tones matter depending, for example, on the types of judicial review or the different legitimate causes for action. So in domestic legal arrangements, for example, public law regimes attempt to clearly separate those institutional functions and tasks, for example, and despite what analytical tools such as the concept of systemic discrimination could contribute for broader legal analysis. So, however, international regimes are quite different from the latter institutional frameworks, and I think it is here where the paper could orient us into a clear or maybe a better understanding of what this concept could contribute in different institutional mindsets. So I worked for 6 months in the petitions unit of the High Commissioner for Human Rights, drafting individual communications, concluding observations, and general comments for CITO and other treaty bodies. And there I observed that the boundaries between the committee's separate powers, for example, communications, observations, or general recommendations, were far more porous in practice than the formal architecture suggests. So individual cases, for example, arriving before quasi-judicial bodies, such as CITO, have by definition exhausted all domestic remedies, which means they already carry within within them a more or less long history of institutional failures or inaction that pushes the committee towards a systemic gaze, regardless of the formal framing of the procedure, which entailed integrating everything into the analysis. So I think this points to a broader question that the paper raises, but I think does not fully address, which is the conceptual value of systemic discrimination may depend heavily on which institutional forum is deploying it and how. So domestic legal systems have developed their own mechanisms to approximate a systemic perspective. For example, constitutional courts exercising judicial review powers, including structural remedies alongside ordinary courts, procedural tools for case consolidation, or, for example, doctrinal innovations such as the Colombian Constitutional Court's estado de cosas inconstitucionales, which is the unconstitutional state of affairs, through which a court, for example, declares a massive structural systemic violation of rights affecting a large group and issues remedies with ongoing judicial supervision. So my question is very brief. Whether the potential analytical value of systemic discrimination is not totally detached from institutional settings. So I think in parts of the paper you mentioned those aspects, but I think it would better illustrate the contribution of this concept, especially for the migration of this concept into more constrained institutional environments, such as domestic courts with limited adjudicative powers. For example, in Chile, where civil or private law judges who are in charge of addressing the judicial claims of anti-discrimination law. So I think, yeah, that's my.
Shall I reply now or shall I wait for a few?
It was 2 minutes.
So I don't know what if it's gonna be not a very long reply, you can reply right away. My worry is that if you do one-on-one,
Okay.
yeah, okay, go.
Okay,
go.
great. So firstly, thank you so much. I think that's an absolutely wonderful set of points. I think you're absolutely right that the analytic value of the concept of systemic discrimination is going to depend, it will depend, its relevance will vary depending on the set of legal institutions we're dealing with. But I also heard you make the extra very important point that sometimes relevant legal institutions will have ways of trying to approximate or understand discrimination as systemic without actually using that concept. So I think that's true. I guess in response to the former point that it's going to depend on the context, I would say, yes, this talk focused mostly on CEDA, frankly, for the very instrumental reason that Rebecca and I are trying to write a paper that provides guidance to the CEDAW committee. So we're thinking of it in that context. But it's absolutely right that if we were to try and use that to provide concrete guidance to particular institutions, like particular courts, we would want to think both about what mechanisms are already in place and what latitude there is for importing this concept in. Yeah. Okay, at another point that I'm on the verge of forgetting, but it was important in response to this nice point of yours that, that it's important to think about the ways in which existing legal institutions like constitutional law and mechanisms of judicial review already allow for some of the recognition of ways in which things like stigma and stereotyping can bleed across contexts, and we need to think about multiple sorts of constitutional rights or human rights violations. So I want to agree with that. I guess I think just as there's value in naming and identifying stereotypes, there's also value in the law being able to name and say, and this is systemic discrimination, rather than sort of covertly trying to take steps to reach the same conclusions. But I think those are really important points. Thank you.
Mm-hmm. Thank you. So we'll do it this way. I think it's better. Pablo.
Good. Good afternoon. Sophia, thank you for the opportunity to engage with your work. This paper shed light on one of the great questions of those of us that are working on the discrimination law, how to approach the phenomenon from a truly systemic perspective. And it's a very robust conceptual framework that will undoubtedly be of great help of those of us dealing with this problem on daily basis, and especially in discrete space affecting specific groups. My questions stem from my area of expertise, the rights of persons with disability, and seek to connect this new article with a general theory you develop in your book, The Face of Inequality. Last year, along with a group of colleagues and students, Gustavo among them, we read and discussed that text. So my question today is heavily influenced by that experience. Specifically, I would like to invite you to explore what I perceive as a conceptual tension in your argument, the apparent friction between the pluralism at the individual level and what seems to operate as a monism at systemic level. In your book, you defend a pluralistic view of harm discrimination. You explain that discrimination can wrong people by subordinating them, denying them deliberative freedom, or depriving them of basic goods. However, when defining systemic discrimination harm in this new work, you argue that it generates a qualitatively different harm, which consists of segregating groups and denying them of full status of citizenship or even as persons. That systemic harm seems to reduce the plurality of the individual level to a single structural effect, which coincides with a very particular form of harm, subordination at the individual level. I will focus in this aspect. I really enjoy the other aspects of the theory of structural discrimination. So my concern arises when applying this framework to systemic discrimination faced by people with disability, and specifically with physical and sensory disabilities like deafness or blindness. I would say that in contemporary democracies, the state and society do not typically operate under a hostile stigma seeking to deny them of their full status. I would say that's different in case of intellectual disability or people with mental illness. I would agree that there is a difference in that. In fact, their status is often formally protected through special rules that help them to deal with the structural inequality that they face. However, through institutional inaction and a design of the world that built exclusively for normative bodies, the ability to enjoy social advantages is destroyed in an interconnected and pervasive way, I would say, structurally. To my mind, this structural inequality is much better understood as a massive affectation of the deliberative freedom and the deprivation of basic goods, rather than a subordination of status. The exclusion from transport, education, or a digital environment does not stem from an intention to subordinate them, nor from the unintentional operation of pervasive negative stereotypes. This inequality is simply the effect of, I would say, invisibilization. The word quite simply did not have them in mind. I anticipate that a possible response to this could be that the material exclusion and the invisibilization are fundamentally a tacit form of denying the status as citizens. That is, designing a world where they cannot participate communicates the message that you are not an equal person. But if we stretch the concept of status denial to absorb absolutely any severe structural exclusion, I fear that the concept loses its analytical power and pushes us toward a monistic theory at the structural level. So I wonder how that monistic comprehension of the harm at the structural level dialogue with your defense of pluralism at the individual level. So the question would be, why commit yourself to the idea that systemic harm must consist in a denial of full status of citizenship?
Thank you so much. This is also a fabulous question. I did not mean in the paper, so you've actually made me seem I guess I presented this in a totally misleading way. The idea of the additional wrong faced by the Afghani women, that was supposed to be sort of an example of the kind of extra wrong we see when we see discrimination as systemic, but not, I didn't mean to then reduce this to status-based wrong. So the idea wasn't that in all cases of systemic discrimination, the extra wrong is going to be a status-based one. But you're quite right that I haven't actually thought through what the other sorts of systemic wrongs were. And you've actually helped me see that there's a really interesting issue here that I'm going to have to think further about, because I guess what I heard you suggesting is that people with physical and sensory disabilities, or at least many such people, the more natural way to think about the systemic nature of the wrong they face is not necessarily in terms of status, but it's in terms of a kind of enhanced set of limitations, like extra limitations to their deliberative freedom. And I'm wondering if, so the idea in the book of denials of deliberative freedom was that often it's oppressive not just in one context, but in several. So there's a sense in which the systemic nature of it is built into that, but not entirely, because I do talk in the book about your people having a right to deliberative freedom on specific occasions. So I think what your really insightful comment points to is that we need to think, or I need to think, since this is my problem, a lot further about how that is going to generalize in situations in which we truly see discrimination as systemic. Is there a kind of additional denial of deliberative freedom that consists, as it were, on these repeated occasions in just having to be beyond the kind of thing that we would think of as relevant to the analysis of individual acts of discrimination? I really appreciate that. Thank you. Maybe we can talk further.
Thank you, Pablo. Lieta?
Yes. I'm very sorry that I forgot my iPad, so I will read from here. But I'm very thankful for this invitation to Rocio and to have the opportunity to comment on your work, Sophia. It has been very inspiring. Also, I really admired Rebecca Cook's work, so it has been very interesting to read your work together and to be with my friends and colleagues here. So, and thanks to you. Yeah, so your framework for systemic discrimination becomes especially powerful when read alongside the figure of the bad victim, I think, a concept central to feminist legal scholarship and to debates around, for instance, abortion rights and criminal law. So the reinforcement mechanism you call individualizing the discrimination operates precisely through this figure. When a woman does not conform to the image of the innocent, passive, deserving victim, institutions withdraw protection and assign blame instead. This is particularly visible in the Chilean context of abortion criminalization, where hospitals, the very institutions charged with protecting women's health, functioned simultaneously as sites of denunciation. So women who sought care after clandestine abortion were reported to the police by healthcare providers, collapsing the boundaries between medical care and criminal enforcement. And this denunciation was not random. It fell disproportionately on migrant women, poor women, and women who did not conform to the image of this good victim. That is, women whose circumstances did not fit the narrow legitimizing narrative of the innocent rape victim, for instance, in the case of rape. So the woman who seeks an abortion is systematically constructed as a bad victim or indeed as a perpetrator through recurring stereotypes about motherhood, moral responsibility embedded across institutions. What is striking from your framework perspective is that these stereotypes do not operate in isolation. The stigma attached to abortion bleeds into obstetric care more broadly, as your Spanish case illustrates, and into how courts assess women's credibility and decision-making capacity, particularly when evaluating whether a woman's account of rape is believable enough to justify access to legal abortion. The reinforcement mechanisms are the same. The context multiply and compound each other. The Campo Algodonero case before the Inter-American Court of Human Rights shows this with particular clarity in the Latin American context. The Mexican state's failure to investigate the murders of women in Ciudad Juárez was sustained by institutional assumptions that these women, poor, working class, some engaged in sex work, or bad victims, were responsible for their own fate. The court held the state accountable not for acts, but for structured omissions driven by gender stereotypes, which connects directly to your fourth reinforcement mechanism. Significantly, the court did not limit itself to compensatory remedies, but ordered transformative corrective measures. Measures aim not merely at repairing individual harm, but at dismantling the broader culture of discrimination that made those omissions possible in the first place. This seems to be precisely the kind of systemic remedy your framework calls for. But Campo Algodonero also raises a question your framework leaves somehow open. What does it mean institutionally to judge with a gender perspective? A standard increasingly invoked in Latin American courts as a practical tool for identifying and naming reinforcement mechanisms. If it means anything substantive, it must go beyond sensitivity to individual cases and require courts to map the stereotypes and stigma that sustain systemic discrimination across contexts. But how? Finally, and perhaps most urgently, given that we are in Santiago in Latin American context, systemic discrimination against indigenous women, for instance, involves features that CEDAW framework does not always capture well. The Chilean case is instructive precisely because it does not have formal legal pluralism, unlike Bolivia or Ecuador. There is a formally universal legal system that applies to all citizens. Yet, in practice, indigenous women, particularly in rural contexts, navigate enormous distances, geographic, cultural, institutional, from the state apparatus that is supposed to protect them. Internal colonialism has produced a specific paradox. Me falta poco. The state has been the primarily historical agent of dispossession and discrimination, and yet it remains the institution women must turn to protection. Your framework is powerful in holding states accountable for structural omissions, but how would it address situations where the reinforcement mechanisms operate precisely in the gap between a formally universal legal system and the lived reality of communities that remain structurally invisible to that system? This leads me to a broader concern about the framework. It is surprisingly silent on intersectionality. The cases you discuss, indigenous women in Canada, women in Afghanistan, the Spanish obstetric violence case, all involve women who are disadvantaged not only on the basis of gender, but through the simultaneous interaction of race, class, ethnicity, migration, etc. So the reinforcement mechanism you identify operate differently and with different intensity, depending on how these axes of discrimination compound each other. A poor migrant woman seeking obstetric care, or an indigenous woman reporting violence to a police force that has historically criminalized her community faces a qualitative distinct set of reinforcement mechanisms than the category women alone can capture. So the question, would you consider intersectionality as a necessary analytical layer within your framework? And if so, how would it change the way we identify and prioritize reinforcement mechanisms?
Wonderful. Thank you so much. There's tons there. Let me just go through in order. I really appreciate the parallel between the colonial context I was talking about in Canada and abortion rights. I think it's absolutely, and you've shown very vividly there that the same sorts of mechanisms apply there. I thought that was really interesting. Can you tell me the name of the Inter-American Court of Human Rights case you mentioned concerning
Campo
Mexico?
Algodonero?
Perfect.
Cotton field, yes. Cotton field.
Campo
Cotton field.
Algodonero. Perfect.
Versus Mexico.
Yes. So that's really interesting. You said the courts suggested some transformative corrective
Yes.
measures, so maybe we can talk further about what those are. I know
Perfect.
often the CEDAW committee tries to suggest transformative corrective measures, but whenever I talk to Rebecca Cook about this, she always says, if they say education one more time, I'm just going to burst, because it's often just so vague.
Yeah, and in the practice in Mexico, things haven't changed that much.
Yeah. I loved the 2 points with which you ended. So firstly, what do we do in these contexts where it seems like there are universal rights being given, but they don't map onto women's actual experience? And this is in a context where the state is the historical agent that, as it were, started oppressing women, but remains the institution that women have to go to. Now, my colleague Mariana Prado at the University of Toronto has done some really interesting work on what she calls institutional bypass. The idea there is that sometimes, particularly in these cases of gender-based discrimination. What went this, now it's still the state, but the thought is the state can set up a parallel institution to try to be sensitive to and really see women's issues. Now, she is Brazilian, and I gather Brazil, somebody can correct me if I'm getting this wrong, but I seem to remember her telling me that in Brazil, they did this with respect to special police forces and courts for women and rape. So they just thought, look, it's hopeless to try to start with a bunch of educational programs with respect to the police. The police as an institution just do not take rape seriously. They don't take women's sexual assault seriously. So we're going to set up a parallel enforcement mechanism. And she has a book on this.
Mariana Prado.
Yes, institutional bypass. So they, which was apparently quite successful, largely staffed by women, by people educated, who in practices of addressing and actually recognizing rape and sexual assaults. And so that's one way to think about that. Lastly, your really important remarks on intersectionality. Yes, of course, you're right. These are deeply intersectional harms. And I think there is a really interesting, it's both a practical question and a theoretical question, right? Because there are trade-offs. On the one hand, if you just think of it generically as discrimination against women, and you're right, I should probably have said more about the intersectional part in the paper. If you think of it generically, you risk losing the nuance and then failing to identify like the accurate stereotypes that are actually compounding disadvantage for these women, you know, because they're not just in Canada women, they're Indigenous women. So they're women who carry with them all of the stereotypes of colonialism and of Indigenous women as being immoral, not like white Victorian women and so on. So you lose that if you think of it more at the level of gender. At the same time, if one particularizes it too much, then there's a risk that we will lose the ability to come together to argue these problems together. So I'm inclined to think this isn't an insuperable set of difficulties. The answer will vary from one case to another, perhaps depending in part on political objectives and on the groups in question. But you're absolutely right that it's something to bear in mind. Thank you.
Yeah, no, thank you.
Thank you, Gustavo.
This?
Maybe
Yeah, this is cool. Yeah. Yeah, both. Yeah, this is the Argentinian spirit. It's nice to talk in English, just not to be confused with my Spanish Argentinian slang. So be safe. Well, thank you for the invitation, Rocio. Thank you, Sofia, for the paper and for the book. Well, my comment is basically based on what you say in page 7 or in page 9, perhaps, and it's based on my practical experience working in the office of the Attorney General of Argentina. My previous experience before coming to Chile as a professor. In Argentina, the committee or the CIDAW General Recommendation 19 and 35, they are both part of the body of legal arguments used to justify decisions such as the criminalization of femicide and various forms of domestic violence. So these recommendations, in particular the ones that said that should be reinforced the obligation of states to prevent, investigate, and punish gender-based violence, addressing it as human rights violation. So I will focus on that, or the way we use, at least, CIDAW in this context. These recommendations in particular are central to the arguments that prosecutors raise in their accusations. So although sometimes this operates with a rather formal or empty framework, but well, that is a different discussion. I mean, they quote this as something that is necessary, but they're not explaining why this is important and how it works in this particular case. But anyway, it's important to notice that we use this as something that is central to the prosecutor's work. In this context, these recommendations tend to move away from the language of discrimination. That would be my point. What they describe appears to be something more serious than discrimination, something that is either different in nature or understood differently. Legal tools are often used instrumentally to confront the deep inequalities that exist between men and women. In practice, they may serve to demonstrate that these acts constitute forms of violence that are distinct from and more serious than mere discrimination. The concept of violence has been recently legally defined in Chile, but in Argentina was recognized a couple of years ago. So my point is to say that when you use the language of discrimination, I read your work and I think that this is more serious than discrimination. So that's why my concern, and that my concern was linked to what happened in the practice or the criminal law practice in Argentina. So that would be the point of my endless question. So there may be perhaps contextual reasons to understand this. Perhaps inequality of our context. We are living in the most unequal continent on Earth. So perhaps this inequality situation obliges us to think this differently. Perhaps we need to took this in a different way, and we think of this as something that is more serious. So my question will be, if we are talking about the same thing, perhaps, or you can say, no, I'm talking about a different type of problem, and related to what Alberto said, could the context make a difference? So perhaps we are talking about the same, but the context make it different, so that's why we label in a different way. Or perhaps what you characterize as discrimination should be understood in our context, or either as a struggle against inequality or a struggle against violence. So what you say, what you name as discrimination is for us a different thing. So that will be mainly my question, comment. Thank you.
Thank you so much. That's really interesting. And I will have to think more about that. So the thought is, look, in certain contexts, such as the context of Argentina, when you actually try and address these sorts of issues, there is a sense that it's preferable to address them as the violence, in terms of to recognize the violence that is going on. And there's a sense, I guess, of that in part because one might say, look, violence against innocent people can never be justified, whereas we're more comfortable with there being existing inequalities, and our sense is that sometimes inequalities can be justified. So is the thought partly that dealing with it as violence brings to the fore the moral seriousness of what is going on in a way that just continuing to use the language of equality and discrimination in certain institutional settings might not. Yeah. So that's a really interesting, I think I take your point, yes. I guess I'm also inclined, though, to think that we can think of the problem of violence against women as also being an equality-based problem. Yeah. And that especially if you think of equality this is not something I say in the book, but of course a lot of countries think of equality as bound up with dignity. And if we think of it that way, then it seems to me it is like as serious. So if we're just thinking conceptually or philosophically, it seems to me that that denying someone's equality is as serious as committing violence against them. Certainly, if you think of all of the young women in Afghanistan, the poor girls now whom you hear, on the verge of suicide, massively depressed because they feel they have no life to live. That strikes me in a sense that that's not literally physical violence, but their beings have been erased. There's been huge metaphorical violence done against who they are. Because why? Well, they have lost all hope of having an equal status. So I guess I want to fully embrace, and I think you're right that I should add in something about how it might be the case that I see this comment as very much linked to Alberto's comment that institutional context matters, and there are ways in which we can talk about and try to address systemic discrimination without necessarily using the language of systemic discrimination. And I think that's absolutely important. But I guess I still want to push for the fact that it's having a robust conception of equality and thinking of the denial of it as a very serious problem akin to violence is useful too. Thanks.
Thank you, Gustavo, and thank you for your patience. I'm the last. I promise to be brief, though I'm not going to be super brief, but I hope you're enjoying, as we surely are. Sophia, I'm going to try to reconstruct something before my question to see if I got it right. So according to your account, one reason why it's important to see discrimination as systemic is that it allows us to broaden our focus beyond the individual agent or act to the reinforcement mechanisms that reproduce discrimination. And this enables us to target the deeper causes of discrimination. The lights went off. And they're back.
That's because you are light.
Mistaken. One such mechanism is the individualization of discrimination through laws and policies. One of these reinforcement mechanisms, which often rely on individual responsibility as a remedy or response to discrimination. This is certainly true of laws that address violence against women by, for example, criminalizing domestic violence and by intensifying the social and individual consequences for offenders, right? Creating the illusion that violence against women is the result of a few bad individuals who are sexist, rather than being the result of systemic discrimination. However, it's probably both at the same time. So you suggest that rather than questioning the existence of these laws or policies that do this individualization, we should understand that they do not solve discrimination on their own and need to be accompanied by measures that address the context in which individuals or policies operate. In the case of domestic violence, for example, we should ask governments not just to criminalize, but also to address issues such as housing policies, universal daycare, extreme poverty, etc., which also are causes of this kind of violence. I think this has been the view of the Inter-American Court of Human Rights, actually, as Lieta suggested, regarding violence against women. They didn't provide a very clear map of what this means, but they I think, agree with you in that sense. They tell the states, you should prosecute and punish, but that's definitely not enough. You need to transform, and that's all it says as far as I can tell. They didn't really say how, but I don't know if the commission may have more insights on that. So that's the view. However, this was, I think, the consequence of that same case of Cottonfield, as they place importance on addressing individual responsibility and making criminal law effective and severe. So the first thing they said is, yes, you need to prosecute and punish, and also you need to do this transformative stuff. But as they put the kind of first focus in individual responsibility, the duty to punish and individual sanctions have overshadowed, I think, the role of other more structural interventions, I think partly because they're easier to do for governments, but I don't think it's just because of that. So my worry is that at least when it comes to individual responsibility in the form of criminal law, the overshadowing is maybe inevitable. I mean, my question to you is like, can we have it both ways? And I'm not sure we can. I'm not sure we can just like accompany to the existing laws other transformative interventions. We need to also transform the individual interventions. So once we rely heavily on criminal law, because of the language criminal law uses and the way in which the criminal law presents what happened, right? What happened is this guy is to be blamed for what he did. He had the freedom to choose to act in another way. And so it sort of sucks all the explanation into this individualized explanation. And it places a stigma also on the offender in the sense that it presents the offender as the sole free, responsible person to be blamed. And this is not just in the way the criminal law expresses itself, but also in the consequence, the punishment. No? How can such a strong, harsh treatment be imposed on someone if not because his action transformed the world in such a horrible way? And so, that I think that we see in practice all the time in Latin American governments. Every feminist that's in the governmental office recognize the importance of transformative intervention, structural injustice, and yet the individual focus seems to suck and makes it impossible to open up this conversation. So, and I think it's partly because of how we understand criminal law responsibility. So I guess my point or observation, I don't know if it's a question, is whether rather than just accompanying the individual with this transformative, we should rethink also what individual responsibility is, what blame is about, what agency the people really had.
That's wonderful too. Thank you so much, Rocio. I think it's, so part of what I hear you saying is this really interesting thing that there's a sense in which it's not an accident and it's not just due to a lack of attention or lack of resources, that the individualization of the problem and the attempt to deal with this through individual responsibility in the criminal law tends to overshadow structural interventions. So it's not just that we somehow get distracted. It's that there's something about the logic of criminal punishment that puts your focus on, that means in a sense that it's only justified if this act was really this person's fault. And if it was really this person's fault, how could it then be really due to structural features? So that's very interesting. And I'll have to think about that. I wonder, so on that note, then, if we think, I'm thinking here about a number of indigenous restorative justice practices that Canada, various provinces of Canada have adopted as alternatives to the criminal law that actually would, I think, seem much more, don't rely on that logic and would seem much more conducive to then being accompanied by structural remedies, because in a sense, they're also themselves structural. If you think that what this person did primarily wasn't just a result of, as it were, wasn't a result of their own badness, and you're not trying in that sense to punish, you're recognizing that in some sense the community has been hurt, and it's the community that requires restoration, and requiring this person to engage in community service or serve the victim's family is a part of broader restorative efforts. Then you can see quite nicely how the structural part would fit in. So that's really interesting. I will have to think about that. I suppose I said what I said more because I imagined that it would just not be feasible to restructure. So I was trying to tack on something else in addition to, yes, what we feel we shouldn't give up. But I think that's a really good point. And I'm inclined to think it actually generalizes to discrimination law as well, right? Similarly in discrimination law, if you're overly focused, right, on individual perpetrators, and especially if you have the kind of focus that the United States does, this obsession with acting according to a certain motive where there's still this quasi-criminal law. You know, at least within North America, discrimination law had its origins in the criminal law, and the aim was to ferret out and punish these acts done with illicit motives because the person was at fault. So there's a sense in which I think your logic still carries through anti-discrimination law there, and so that part of it would have to be fundamentally transformed in the way, for instance, that Canadian discrimination law, at least formally, we have, our Supreme Court said, look, we're going to abolish the distinction between intention-based and effects-based discrimination. Really, the wrong is purely effects-based, but in cases where it's really prejudicial or there's a kind of heinous, deliberate, malicious act of exclusion, you can get additional damages to recognize a kind of additional dignitary harm. But primarily, it's a problem in the world with its effects on victims. You can see how that way of thinking of discrimination is more amenable to systemic remedies because the problem is thought of as a problem in the world. So thank you. Yes.
Okay, so we've reached the part of the conference where you are all invited to make questions, comments if you want. I'm happy to translate into English if you prefer to ask in Spanish. And also if one of the panelists here wishes to make a question, another question, a further question, go ahead, but please raise your hand if you have a question. Yes, I'm gonna carry the... because we have some people actually online.
Okay, there are the people online.
Ya.
Yo te traduzco.
Ya, sí, gracias. Bueno, muchas gracias. Mi inglés está bastante oxidado, así que prefiero hacerlo en castellano. Creo que es muy interesante el trabajo que se hace desde la discriminación sistémica y ahí, porque en la jurisprudencia interamericana, o sea, de la Corte Interamericana de Derechos Humanos, igual es un concepto que si bien no es absolutamente coherente, porque los casos también tienen distintas menciones de discriminación estructural, cultura, bueno, distintas. Hay un caso que es del año 2024, que es un caso de racismo estructural. Y ahí es muy...
Wait.
así.
So she first says it's very interesting the idea of systemic discrimination, and she wants to say also that in the decisions of the Inter-American Court of Human Rights, we need to be sure to know that not all the decisions have the same ideas, something like that, no? Como they are heterogeneous. There's not like an homogeneous. Okay.
Claro, y no hay un concepto
And
como,
there is a
como
particular case.
homogéneo sobre discriminación estructural que tiene la Corte.
Yeah, the court doesn't have a homogeneous concept of structural discrimination.
Pero lo que sí que ha ido desarrollando y que es un caso del 2024, que es un caso de racismo estructural, en donde es muy interesante que uno de los votos, sobre todo uno de los votos concurrentes, habla de, y en esto de los remedios, ¿qué hacemos? ¿No es cierto? Ya no podemos seguir hablando de educación porque, y más educación, habla de desmantelar las instituciones racistas.
Yeah.
Ahora,
So what has been developing is to, through some cases, particularly in a case of structural racism from 2024, is to develop the idea of what do we do, like how do we address it? And there's one vote that also says like no more education. We really need to do something else, or.
claro, y ahí habla de desmantelar las instituciones.
Yeah, and it presents the idea of dismantling, I think, the racist institutions. Yes.
No, pero igual falla en cómo hacerlo.
Ah.
Y que es el gran problema. Entonces, también la pregunta un poco era, ¿qué más aparte de educación podemos hacer? Porque yo creo que es la gran pregunta que al final, ¿cómo lo hacemos? Porque podemos modificar ciertas normas, podemos modificar ciertas políticas, pero parece que hay algo muy institucional y estructural que de todas maneras sigue manteniendo y perpetuando. Y a pesar de que modificamos justamente las leyes, se sigue. Entonces,
So the court said, well, we have to dismantle the racist institution, but they didn't say how to go about doing that. And so her question is like, sort of going back to the question of, well, what do we do to actually, like, besides changing the norms and policies, the practice continue to reproduce themselves, and what can we do beyond education?
Yes, that is an excellent question. I don't have a good general answer, but I am inclined to think there are smaller things we can do in local contexts that help, and they will be different. So for instance, with respect to coercive sterilization of Indigenous women in hospitals, it's actually, that seems tackleable. The problem is that the government just repealed laws requiring coercive sterilization, but didn't actually require hospitals to then ensure that doctors didn't coercively sterilize. So it's perhaps a mix of increased education and programs for the relevant doctors, regular inspections by governments. Will this fully address the problem? No, but it's probably going to be a lot better than doing nothing. So that's one instance. With respect to other things, well, let's take transportation policies. This is a big issue in Canada. Lots of transportation money is pumped into urban areas, partly actually to address problems of discrimination and racism in urban areas, but then this leaves Indigenous women on reserves, very vulnerable to domestic violence and actually unable to become financially independent. So there, it's more actually a matter of money. They need money and transportation infrastructure. So there, in a sense, the problem isn't that we can't craft a good remedy, it's that we need the political will to put money there rather than putting it somewhere else. But this is a key question, what more beyond education? Perhaps I can trouble you to email me the name of that case. That would be very helpful. Thank you.
Thank you. Anyone else would like to make a question? Oh, yes. Yes. Santa, if you can pass me the microphone.
Hello. Thank you very much for the presentation. It was very interesting. I had a question maybe related, or maybe in the sense that Professor Kudu made an observation, which is how much does confronting discrimination or arguments made against discrimination, how much do they have a place in judicial decisions, depending on what type of discourse take a part of these decisions? So I'm thinking, for example, Duncan Kennedy's analysis on how policy discussions are inserted into appellate court decisions because judges take it upon themselves to take on decisions with policy arguments, and therefore political intelligentsias make these arguments in these cases because they know they can affect, broad spaces of the country. But courts in which those discussions do not take place explicitly, for example, the Chilean Supreme Court in Chile, it's even considered a violation of the code of ethics for a lawyer to bring in political discussions within a case. So I'm wondering if the issue regarding discrimination depends somewhat on how these issues can be discussed in a court of law. And also maybe, and I'm thinking now the first thought that came to mind is in regards to maybe other forms of responsibility that don't have the same limitations as criminal responsibility. For example, tort law. In Chile, there has been some recent literature on the regulatory function that tort law can have in cases of tsunamis. So, for example, when there was an earthquake in 2010 and there were tsunamis that weren't alerted by the government in time, there were a lot of suits filed against the state, and that had the effect that the state implemented a lot of measures in order to prevent this from happening again. So I was wondering maybe if there are other forms of responsibility that can, because of their flexibility, be much more effective in that sense.
Really interesting. Thank you very much. So on your 2 points, so the first I think is, yes, absolutely. I think different countries have different traditions with respect to the extent to which academic writing or policy discussions can be deliberately aimed at a court and then taken up, or, in Canada, academics mail their articles to judges and it's perfectly fine. And there's a kind of dialogue going on between the two of them. I participated in a project run by the Mexican Supreme Court a couple of years ago where they invited academics in to talk to judges about various ideas of discrimination. But obviously that won't happen everywhere. I like to, maybe it's an overinflated view of academic influence, but I like to think that academic writing and writing within a political culture will mutually influence each other, and that in more diffuse ways will affect how judges think about the laws that they're reasoning about. So there'll be that kind of diffuse influence regardless. With respect to your second really interesting suggestion, what about tort law? So I actually also teach tort law, and I'm going to be co-editing this big volume on social justice tort theory, which is something that I've done. But as a result of teaching tort law and trying to think about tort law as a mechanism for achieving social justice, I have become a little more pessimistic about its prospects, partly because, of course, in these cases where the people suffering from the harm are disempowered and without financial resources, it's often the case that you can have as wonderful a set of tort laws as you like, but if nobody in the relevant group is actually has the fiscal resources to take advantage of it, it's problematic. With respect to domestic violence, this scholar, Martha Chamalis, that I mentioned earlier, has actually argued that we should try and deal with it through tort law. And Canada tried briefly. My province flirted with the idea of a tort of domestic violence. But as you can imagine, it's kind of unclear how this is going to work. Nobody who's in a really abusive relationship is going to want to aggravate things by bringing a lawsuit against their abusive spouse. She said, "Oh well, all couples we should have domestic insurance available for domestic violence." I also who at the start of their marriage, in addition to their wedding vows, is going to say, "And honey, we should really purchase some of this domestic violence insurance." So I don't know about that. I do think you're right that there are ideas of responsibility that it's very useful to draw on, and I've tried to do that in some of my own work on discrimination. So the aspect of your suggestion that is thinking along the lines of, look, there's a very good notion of responsibility here that we can harness in other areas of the law that doesn't fall prey to the law kind of logic that Rocio mentioned, whereby we're thinking of it as being this individual's serious fault and only their fault. I think I agree with you completely that that would be useful in some way to bring in when we start thinking about people who are at fault in a context of systemic discrimination. But maybe we wouldn't want to do that necessarily through tort law. Yeah.
Thank you. If there are no more questions, I invite you all. There is one more question. And then I will invite you all to have a coffee downstairs. Okay.
I mean, I think the question about what the remedies is the most interesting, right?
Yeah.
And I would say that one thing that is relevant to have in mind when you think about remedies, especially to dismantling harming stereotypes and stigma, is not only to focus on the whole and the individual.
Yes.
Right? So it's not society that holds the stereotypes only, and it's not a few individuals that hold
right. Yes.
right? So I would say that it's important to look at some intermediate groups
Absolutely.
that are sort of especially relevant to maintain stereotypes. And I was thinking, especially in the case of Spain, you wrote in the paper, of the medical profession and the judiciary. There are two groups of professionals that are especially difficult to make accountable. They have certain autonomy to reproduce their worldview and their professional view on certain issues. And I think especially in disability discrimination, medical profession is especially problematic, right? So I would say the views on remedies that we need to think about, not only dismantling sort of state institutions or teaching at the level of schools, not being racist or not being ableist, but also to intervene in these groups of like intermediate groups that are, are carrying these stereotypes forward. Very, very important.
I think that's absolutely right. Yes. I appreciate the focus on these particular professions, partly because of their status and the way in which they reach into so many people's lives. For those two reasons. I was thinking also it's important to think about stereotypes not as things in people's minds only, but as embodied in particular institutions. And that's partly why at the start of the paper I gave the example of the gypsy room, because there's a very, vivid way in which just having a gypsy room in a hospital embodies this stereotype that they're unclean, they need to be separated from the rest of us, they're not trustworthy, so lock them in their own room. And so even if no one has that image in their mind, that's, as it were, what the institution is putting forward. And so I was thinking we need to think about not just what is in individuals' minds, not just society as a whole, but as it were, what our physical architecture and the policies within institutions kind of embody as their own rationalizations, and often those have these stereotypes that we can try and chip away at.
Okay, thank you very much. So I invite you all now to go to the first floor and eat, because there's a lot of food and drink, and also to give an applause to our panel and to Sophia and to you. Thank you so much. And please, whoever came and didn't sign the list outside, please sign the list. Thank you. It's just so I can...
Appreciate it.